Hello and welcome to our update on the Employment Rights Bill. I'm Claire Rosney, a professional development lawyer here at Brown Jacobson, and I'm joined today by Emma Capper, who's our Head of Employment. Now, it feels like we've been talking about the Employment Rights Bill for quite some time now, and indeed it is just over a year since it had its first reading in the House of Commons. Yet at the time of recording, it is still to become law. And I know, Emma, that you've had lots of clients asking about this and asking, when will the changes come in? So we thought it might be useful to just do a recap of what is the Employment Rights Bill, what's the current position, the key topics that we think are most of interest to employers, the four key questions that are on our minds, and the next steps. So, Emma, what is the Employment Rights Bill all about?
Thanks, Claire. So the Employment Rights Bill has been stated to be the most comprehensive overhaul of UK employment law that we've seen in decades. It introduces 28 major reforms as part of Labour's flagship Plan to Make Work Pay agenda, and it will fundamentally reshape worker protections across England, Scotland, and Wales. The aim is to deliver on the Labour Party's key manifesto commitments to strengthen worker security, tackle exploitative practices, and modernise workplace rights. And there are going to be sweeping changes to areas such as unfair dismissal, discrimination, and how employers are using temporary labour. So for UK employers and HR professionals, the legislation is really going to require a fundamental reassessment of employment practices across all sectors.
Thanks, Emma. I think it might just be worth us summarising where the bill is up to. So, over the summer, we did see a number of non-government backed amendments that were surprisingly agreed at the House of Lords report stage. Now, some of these did undermine some of the government's flagship manifesto promises, such as the day one unfair dismissal rights and right for zero low-hour workers to be offered a guaranteed hours contract after a period of time. Unsurprisingly, when the bill returned to the House of Commons on the 15th of September, these non-government amendments were rejected. So what happens now is the bill needs to go back to the House of Lords for consideration of the comments, amendments and/or reasons. However, this isn't now scheduled to take place until the 28th of October 2025 because we've had recess due to conference season. Now, when the bill does go back, there is the potential that it will be headed for a period of what's known as ping pong between the two houses, where the bill essentially passes back and forth between the two houses until agreement is reached. However, I think it's likely that the House of Lords will give way because parliamentary convention does dictate that the House of Lords will not stand in the way of key manifesto promises. So it's only at the point that both houses are in agreement will the bill get what's known as royal assent, and essentially this just confirms the final version of the bill and it sets a specified date on which it will become law. So what do you think are going to be the key topics in this bill that employers are going to be most interested in, Emma?
Well, I think there are four key topics for me that employers will want to know about. The first is unfair dismissal rights. So there's been lots of discussion about this already, but the plan is that unfair dismissal will become a day one right, which is a big change from the current 2-year qualifying period. I think the second area is collective redundancies. The bill will introduce changes to collective redundancy consultation triggers that will mean that employers will need to collectively consult in more situations than they do at the moment. I also think protection from harassment is a key area. So third-party harassment makes a return, with employers being liable if they fail to take all reasonable steps to prevent harassment by third parties. But unlike the previous provisions that you might remember, there's no 3 strikes rule. And so employers will be liable for a first instance of harassment unless they've taken all reasonable steps. And then I think the last one for me is the ban on NDAs, non-disclosure agreements. This is another big change because, broadly speaking, NDAs that cover harassment and discrimination at work will be banned in employment agreements unless it's what's known as an accepted agreement. Which topics do you think employers need to keep an eye on, Claire?
Yeah, I completely agree with all those that you've listed, especially the ban of NDAs, which of course wasn't in the original bill and was something that was snuck in during its passage through Parliament. I think for me, in addition to those, if I was going to pick four, I would probably say the ban on fire and rehire. So, as amended, the bill will ban fire and rehire dismissals, where the proposed contract change relates to pay, pensions, hours of work, or holiday entitlement. There's some other minor things, but those are the big ones. Now, it has been significantly diluted from where it first started, where a ban on all kind of fire and rehire would have effectively come into force if the bill becomes law. So now it is, as I say, limited to these what are being called restricted variations. But I think, that notwithstanding it's been diluted, I think it is still going to be a huge change. Now, if you think about, what was the policy behind this or the objective, it was to outlaw fire and rehire practices where existing workers were dismissed and replaced with cheaper agency workers. So you might remember the P&O ferries case a couple of years back. But as you and I will know, Emma, P&O ferries cases are the exception, rather than the rule. And the more commonly used scenarios of fire and rehire is where an employer is seeking to agree either contractual changes or to relocate a workplace. So obviously it's going to be a lot more restrictive than what employers are used to. So I think that's something that a lot of employers will be keeping a close eye on, especially in the current economic climate. I think the other big one for me is going to be the zero low hours contracts. Now, these are seismic changes that are being proposed here. By and large, employers have had pretty much a free rein to decide how they organise their temporary workforces. And have people that they can engage through sort of peaks and troughs. But this bill does seek to introduce complex changes to zero hours contracts, including an obligation on employers to offer guaranteed hours based on employees' work pattern in a previous reference period. And we know as well that, this will also extend to agency workers. So again, I think a lot of employers, especially in sectors that are using temporary labour. So I'm thinking we've got Christmas coming up. Retail will probably be one of them. Hospitality will be another. I'm thinking probably health, NHS bank staff. This is going to be huge, I think, for them. I think as well for me, the trade union reform, I mean, again, these are wide ranging and include things that are probably less controversial, I think it's fair to say, such as repealing the existing strikes minimum service levels. Now, to my knowledge, this legislation was never used when it came in. So, probably not going to be a massive change for people there. But I think other changes here, such as the trade union rights of access, which will provide trade unions with access to the workplace, and as well simplifying industrial action ballots. So we could see, more instances of industrial action. I think, again, employers will see changes here. And of course, the other big thing here is will there be an increase amongst employees who now want to join a union? So potentially, will there be more approaches to employers for trade union recognition? And then I think the last one for me is the Fair Works Agency. Now, on the face of it, you might think, not such a big change. It's a new state enforcement agency that's going to bring together existing enforcement functions such as national minimum wage, statutory sick pay, labour exploitation, and modern slavery. But the key change for me is it's going to add in holiday pay enforcement. Now, holiday pay is one of those areas that a lot of employers get wrong, not intentionally. I think it's fair to say. It's just you and I will know, Emma, the holiday pay rules, again, complicated, difficult to understand, and inadvertently, some employers do become unstuck. And of course, that's given way to a lot of litigation. So, intention is here to have enforcement functions under the Fair Works Agency in relation to holiday pay. So, I think, again, that could be quite a big change for employers. I think as well, there's a lot of questions around this legislation, and I think a lot of things will be keeping employers and indeed us employment lawyers up at night. Emma, which are the big things for you?
I think Claire, the unfair dismissal
Yeah.
day one right issue is forefront of a lot of clients' minds at the moment. So, what will this lighter touch process look like? Um, and how is that going to work in practice in terms of dismissing employees in that initial period? And might we see a return to the old statutory dismissal procedures that some of us might remember?
Well, I certainly remember them, and yeah, enough to send a shiver down my spine, as well as I would imagine a lot of employers, because actually, what they did was just add another level of complexity and more litigation.
That's right. And then I think the second one for me is the ban on NDAs. So, given that this was introduced, you know, a bit later on, how restrictive will that ban be? What will amount to an agreed exception? Might we look at moving towards an Ireland model, for example, in relation to the ban on NDAs?
Yeah, I think that's going to be a huge change. And of course, all eyes are on what is going to be this agreed exception. Will an NDA be permissible where the employee requests it? But, I think for, employers, this again is going to be a massive change because, my experience, most agreements, whether that be a settlement agreement or a COT3, would include a legitimate confidentiality clause. And again, not always at the request of the employer, but equally the employee. I think for me, if I was thinking about the big ones, again, I just think it's fire and rehire. Um, the provisions are diluted, but they are still restrictive for employers. So I think the big question a lot of employers will be pondering is, well, what are my options where I need to reduce costs, but I'm not necessarily facing that imminent and financial collapse, which of course is the really high test that is embedded into the new rules. Will employers therefore need to be looking at redundancies instead? Could we see an unintended consequence of this legislation where actually jobs are lost rather than preserved because employers don't have as much flexibility now around things like, fire and rehire provisions? And I think the other one is just going to be the zero low hours workers. I find them complex. I'm not sure how employers and employees are going to get their heads around these new rules, and I just question: are they going to be so complex that they're actually just not going to work in practice? And what does that mean? Does it mean that employers move away from engaging, temporary workforces? So yeah, I think a lot of employers are going to be um, keeping a close eye on that one.
Yeah, I agree, Claire. I think those are the four areas that we're seeing most questions on at the moment from our clients. I think others on the list are still important areas for change, given that it's 28 areas of reform. But those are the key ones I think that employers are most concerned about at the moment. So, what are the next steps, Claire, on the employment rights bill, and when will we know more, do you think?
I mean, it's really difficult to say, and I really wish I had a crystal ball here. I think my gut feeling based on what we know so far, is that royal assent's probably likely to be maybe early to mid-November. But I think the key thing for employers to just bear in mind is that even when this bill becomes law and gets royal assent, not everything changes immediately. In fact, there's only, relatively few of the bill's provisions that are going to come into force either upon receiving royal assent or shortly after. So the first things that will come in will be things, like I said, probably quite non-controversial: repeal of the Strikes Minimum Service Levels Act. There will be repeal of the great majority of the Trade Union Act 2016, removing the 10-year ballot requirement for trade union political funds, simplifying the industrial action notices and industrial action ballot notices, protection against dismissal for taking industrial action. But I think the key thing to be remembering is that a lot of the provisions in the bill actually do require what are called commencement regulations that will bring them into force. So basically, the act as it will become gives the right to make laws about things like unfair dismissal becoming a day one right, but it will actually require further substantive regulations together with associated consultations before these rights can actually be brought into effect. Now, consultation's a really interesting one because, of course, the government did set out a roadmap a few months back, which said that it would start consulting through 2025, going all the way through into 2026. And we can already see that some of those consultations, the timescale has slipped. Because the consultations haven't been released yet. Now, obviously, we did have some personnel changes in government, so that could be a reason for the slippage. And of course, it remains to be seen whether it impacts further the roadmap. But I think the consultations are really important because it's once we see those that we'll start to see the detail of what the government is proposing and how things like you mentioned this light touch process on the unfair dismissal, how things like that are going to work in practice. The other thing I think it's just worth bearing in mind, though, although we might have had a little bit of slippage on consultations, if we look at that roadmap timeline, most of the substantive changes are not going to come into effect until later in 2026, and indeed 2027. We know that day one unfair dismissal rights is scheduled for 2027. So even though there's been a little bit of slippage now and the bill still hasn't had royal assent, I don't think it will have a massive impact on, as I say, the bigger changes that are going to be coming in, because they are still some way off. I think it's quite difficult then for employers to know what to do now. I think if I was advising employers, I would say start thinking about which of your policies and practices might be impacted by the measures in the bill and what changes may be needed. But of course, just also bear in mind that things could still change as we start to see that secondary legislation. So I think if employers were thinking about making changes to policies, processes, notwithstanding the Employment Rights Bill, I'd say get on and do it. If they are thinking about bringing changes in that could be impacted by the bill, then I would say perhaps just wait until at least we start seeing some of the consultation. I think, Emma, though, it's fair to say, isn't it, that the one thing we can say for certain is it's going to be a big change for employers and for lawyers. There's a lot there to get to grips with.
I think that's absolutely right, Claire. Yeah, definitely watch this space.
Yeah, and on that, we are going to be shortly launching our Employment Rights Hub on our website, where you can stay abreast of all things ERB related. So hopefully, as we know more, we'll be able to bring you further detail about what it means and how things are going to be changing in practice. I think that was pretty much everything, Emma, unless you've anything to add.
No, that's great. It's been good to talk to you today, Claire, and thanks everyone for listening.
Thank you.